I think I'll just go ahead and get started with the score slides, and people can continue to join us. So welcome again. We're happy that you've chosen to spend a bit of time with us this evening. My name is Anita Coyote. I am a SCORE mentor, and I'll be giving you a little bit of information about SCORE, and then I will turn you over to Tyler Bruley, who is also a SCORE mentor. He's an attorney and an expert in contracts. So I think you'll have an opportunity to get all your questions answered. I will point out that you will get a copy of the slides and a link to the recording, so you don't need to worry about taking notes. So I am going to give you our little SCORE commercial. SCORE is one of the largest networks of free volunteer mentors in the nation, and we will help you no matter what stage your business is in. So if you go to our website, you can request a mentor, and someone will get in touch with you within the next 48 hours. So our mission is to foster vibrant small business communities, and we do this through mentoring and education. We hope that you, as a small business owner, will have all the resources you need to be successful. We're well aware that small businesses drive the national economy, and more than 95% of businesses are small businesses. So it's important that you have an opportunity to get started and maintain your business, and we're here to help you do that. We have people from all walks of life. About 10% of our clients are veterans, and more than half of our clients are women. So a lot of women are starting businesses these days, which is absolutely wonderful. Here are some statistics for our chapter. In last year, we were named Chapter of the Year for the entire country, which is an honor. As you can see, we cover counties all along Lake Erie, from Ashtabula in the east to Erie counties in the west. Our services are free. We don't charge because we get funding from the Small Business Administration, but also we get a significant amount of funding from businesses in the Cleveland area. So we do not charge for any of our services. Just to mention, we have upcoming a networking situation for all of our all of our clients on September 12th, and we welcome you to join us. It's an opportunity to network with other small business owners and also with mentors. We'll have a lot of people there that may be helpful to you in your business and also help you grow your business. This is a snapshot of our website. If you go here, you can request a mentor, take a workshop, browse our resources. You'll find all kinds of templates, all kinds of articles and blogs. All of our webinars, we record them live on YouTube and play them back on our website. So if you want to catch up with some of the webinars you've missed, go to our website under recorded workshops and you will find them. So I'm going to stop here and turn it over to Tyler. So it's all yours.
Thank you. All right, let's see if I can't get this shared correctly. So for the last time I did this, I wanted to do something weird. Yeah, all right, I'm gonna try and do this a little bit better. Fix that from the beginning. Let's see if I can actually share it properly this time. Okay, I think everybody can see that properly now. Oops. All right, hold on. I'm still having technical difficulties here. I don't want to show the preview. I just want to show the see slides. Oop. Oop. Well, let's just do that then. Okay, everybody can see this now.
Yes.
All right. So, as Anita mentioned, my name is Tyler Bewley. This is part of the legal series. We are going to talk about business contracts, and then we're going to talk about insurance very briefly at the end. So who am I? I am a business lawyer. I practice in Westlake, Ohio at a law firm called Seeley, Savage, Ebert, and Gurash, where I practice mainly giving business advice in the areas of mergers and acquisitions, as well as real estate. I do a little bit of labor and employment, and really a lot of the things that touch and concern a business. And of course, that includes all kinds of different types of contracts. I used to be in-house counsel for a automotive dealership group before I was in private practice. So I really understand how businesses operate, how they think, because I used to work in-house for one. Right. So legal disclaimer before we get started. Let me make sure that, hold on one second. I just want to make sure that everybody can hear. Okay, yeah, all right. So this presentation is for educational purposes only. It's not legal advice. So you should consult your own attorney about each of your very own specific legal issues. And finally, no attorney-client relationship will be established here tonight. So what to expect in this presentation? It's really split into, I think, 3 parts. The first part will sound more like an English lesson where we're going to look at sentences, different types of sentences in contracts and what they mean, because they're not as self-explanatory as just reading a book, right? They mean different things under the law. We're also just going to talk about high basic level contracts and how they're interpreted in common law versus statutes, and contractual language. And then we're going to move into sort of what I would say is part 2, where we're going to actually look at different common types of contract provisions that small businesses see a lot and that are very important to small businesses. And then, we might talk about where there might be room for you to negotiate, things that you should negotiate, things that are important and can be of concern to small businesses. The last part, we'll talk briefly about insurance. And then, spoiler alert, you're not going to learn everything you need to know to be a lawyer at the end of this presentation. Unfortunately, it takes years of schooling as well as lots of experience, right? So, but hopefully this kind of arms you with at least the knowledge of when to ask questions, what might be confusing when you're reading a contract and signing up for something, as well as when it might be time to get a lawyer involved. All right, so why is it important? Well, number one, just because you don't know what's in a contract doesn't mean that it's not enforceable against you, especially as a business. So if you're signing it as a business, businesses get much less protection under the law and under statutes because a lot of the consumer protection laws don't apply to businesses, or they don't apply in the same way that they apply to consumers. And one of the examples of that is usurious interest rates. So interest rates that are super high, Businesses are allowed to sign up for those. You're kind of deemed knowing that you're a business expert and you know these things, not as a consumer. So one of the most important things from this presentation is read the contract, right? Don't just go blindly signing things, especially if it has personal implications. If you're signing, personal guarantees on things, that stuff can follow you, even if your business fails. All right, so alluded to this. There's contract law. There's, so what's in the contract? Although not everything in a contract is always enforceable, usually it is, but sometimes there are instances where it's not. Statutes, so those are the things that are actually codified in the law. So each state has state statutes, there's federal statutes in the United States, and then there's also municipal ordinances as well. Sometimes those things are waivable in contract. So you can say, you waive your right to X, Y, or Z under the law in the contract, but it's not always. Some things aren't waivable as well. Common law, that's law that's created by the courts, right? Those are also going to apply to contracts in some instances. So common law and statutes, even if it's not in your contract, might still apply, right? So just because it's not in writing there in your lease agreement, for example, doesn't mean that there's not something in the common law or statute that applies in that situation and gives either additional rights to you or the other party. And same thing with statutes and ordinances. Sometimes they're waivable in contracts. You can waive certain rights. So anytime you see any kind of waivers or it says you waive something, you really want to think about that and maybe even go and look up the law to the best you can to see what you're actually waiving. So the types of contract provisions we're going to talk about today. Intro paragraph, right, where we talk about the parties. We're going to talk about the recitals or the background. Sometimes they're called whereas clauses. We're going to talk about definition sections, how different terms are defined in contracts, declarations, representations and warranties, conditions, covenants, which are what most people I think of when they think of what's in a contract, or covenants, rights, discretionary authority, and then lastly, the signature block. So jumping right in, the introductory paragraph of contract kind of looks like what you see below there. It tells you who the parties are, sometimes where they're located. It'll define the parties. It will also usually give an effective date. So when the contract is effective between the parties. And then definitions, there's a couple of different ways you can define things in contracts. Some larger contracts will actually have definition sections, and then they'll have in-text definitions. So whenever you see a capitalized term in a contract, that means it's a defined term, almost always, unless it's someone's name, it means it's a defined term. So here, business day means any day, except Saturday or Sunday. In Cleveland, right? You see it capitalized there, and then it says later down, this is outside of the definition section. The purchase price shall be paid by wire transfer, no later than 2 business days. And you see business days are capitalized there. So that's not just saying business days; it's saying this whole definition. And then the other way to do it is in text definition. So this contract purchase agreement. Well, you see the little quotation marks, the agreement, that's referring back to this contract purchase agreement. So those in-text definitions go backwards and they refer back to whatever came before them. And then you see is entered into July 1st, 2022. That's the effective date. And then you see these parties definitions as well. Recitals or background. Like I said, these are the whereas clauses you'll sometimes see. Or it's the part that comes right before the in between the preamble, the introductory paragraph, and then the part where it starts talking about the meat of the contract. It says, hey, this is what's going on. This is the history. It sometimes talks about the party's intent. And unless you incorporate this stuff into the agreement, it's not enforceable. The definitions can be, so you can define terms up there that are enforceable in the contract, but you saying seller is engaged in the business of selling widgets in the background doesn't mean that, seller has to sell widgets and has to be in the business of selling widgets. That part is not enforceable. It's just background. So this is where we're going to start talking about the different types of like sentences, I guess, sentence structure. It's going to sound like an English class, right? So things like declarations. So all that is it's saying, it's a statement of the fact as to which the parties agree. So it's oftentimes you'll see these in the definition section and established policies in the contracts. So questions to ask yourself: is the business term a definition? Does it establish a policy? To determine if it's a declaration, ask, would a party want a monetary remedy if it were not true? If yes, it's not a declaration. And an example of that, if an easy one, is purchase price means $200,000. So representations. Those are things where you're saying you're representing something to the other party, right? So it's a statement of fact as a moment, as of a certain point in time, and it's intended to induce reliance by the other party. So you want to induce them to do something. You're going to say, well, here's my representation. Now that you know that, you're going to enter into this contract, right? And the remedy for violating or breaching a representation, so if you say something that's not actually true in a contract for a representation, if it's innocent or negligent misrepresentation, you can get avoidance and restitutionary recovery. But for a fraudulent misrepresentation, so you had some intent, you knew about it, you can either get avoidance, so meaning get out of the contract, or get restitution or damages. And sometimes punitive damages. And so the question you want to ask yourself to determine whether it's a representation is, has a party said something on which the other party is relying? Here's an example, consents. So this is just a consent provision out of a contract, probably an APA, an asset purchase agreement, where the seller has obtained all consents required in connection with the execution and delivery of this agreement. Then it's referring to a schedule. The seller has obtained all consents required in connection with the consummation of the transactions that this agreement contemplates. So you're representing to the other party and saying, hey, I've already got all the consents that I need to do this deal. And then usually there's stuff that goes off with that. Warranties. So oftentimes you hear representations and warranties, right? Because usually they're done at the same point, right? You represent something and then you also warrant it. And so you promise that the statement is true. So you represent that the statement it is what it is. And then you say, and I promise you that that statement is true. So usually the business purpose is to provide an indemnity, which we're going to talk about indemnities, if a statement is not true, to allocate risk. I meant to say it is to allocate risk. And so the remedy there is damages, right? So it's going to be monetary damages. And the question you want to ask yourself is, has a party said something on which the other party is relying? And if so, that's a warranty, right? It's like when you go and buy a product, right? You're buying that product knowing that they've got a warranty that they're going to, fix material defects. Okay, well, they've said something to you. They've given a warranty. They said that they're going to fix it if it's broken, right? If it's got a material defect. And then you're relying on that, and that's making you want to buy the product, right? Same thing in a contract that these warrants are, that warranty does. So an example here, the manufacturer warrants to the retailer that the product as packaged and shipped from the manufacturer's plant will be free from defects in material and workmanship and will function and perform in accordance with the manufacturer's specifications for a period of 1 year from the date of retail purchase. So covenants. This is what I think most people think about when they think about contracts, right? Is, the almighty word shall. The seller shall obtain all the consents listed in Schedule 3.8 for the closing. It makes you do something. It's a promise to do something or not do something. You can have negative covenants. And so it establishes that duty. Sometimes they're also called obligations to perform. And the business purpose is to require or prohibit action, right? It's to make somebody do something. Sometimes it's to also establish standards of liability and to allocate risk. So the remedy is damages, and then if appropriate, for certain circumstances, and usually if it's actually spelled out, you can get specific performance. And specific performance is just making the court making you do something, right? So specific performance example would be in a real estate contract. Let's say there's a breach and the seller doesn't want to sell the property. You can go and get specific performance making the seller sell you the property. All right, the question to ask there is, has a party promised to do something in the future? All right, rights. So a little bit different. This is, it's your right to do something. So it's the party's entitlement to the other party's performance of a covenant. And so a right is the flip side of a covenant. So the example here is if the executive breaches her duty of confidentiality, the company has the right to equitable relief. They don't have to, it's an option, but they have the right to equitable relief. And so it's to require or prohibit action, to establish standards of liability, and to allocate risk. And it's the same remedies we just talked about for a covenant. So condition to an obligation, these are going to be your if then must statements. So if then, and so condition to an obligation is a state of facts that must exist. So that's your if, before a party is obligated to perform. And that's the then and then the must. And then the occurrence of the condition must be uncertain to be a condition to an obligation. And so the business purpose for this is to establish when a party is obligated to perform a covenant and to allocate risk. And so the remedy is going to be a condition to an obligation, condition to an obligation cannot be breached, and its failure to occur means that the obligation to perform is not triggered. And if the failed condition does not affect the party's ongoing relationship, the condition is an ongoing condition. And if the failed condition permits one party to choose whether to perform, the condition is a walkaway condition that creates a walkaway right. Meaning you can walk away from the contract, right? That's usually how you see them happen, is that, something has to happen before you have to actually perform or like close on the deal, right? So inspections in real estate contracts, right, are conditions to close, right? Conditions to an obligation, which the obligation is to close. So the questions you want to ask to yourself to determine whether it's a condition to an obligation is, does the business term require that one thing must happen before another thing happens? And stated differently, must events occur in a chronological sequence? And as I said before, these are usually if-then statements. And so here's an example. If the owner suffers a loss because of theft or unintentional damage, then the owner must give the insurer written notice of the claim no later than 10 days after the loss. Discretionary authority. So this is, you get similar to the right, you get, there's an option, right? The right to choose what action to take, and permission to act. So the business purpose here is, like I just said, to provide choice or permission, and then to allocate risk. There's no remedy here for discretionary authority. And usually these are identified by may, the word may. So if an event of default occurs and it's continuing, the bank may waive the event of default or exercise its remedies. There's the choice. They can do nothing, they can waive the event of default or exercise its remedies. So now we're kind of moving into part 2, which is common contract provisions. So we're going to talk about term, termination, and renewal. We're going to talk about defaults. We're going to talk about remedies, choice of law and venue, indemnification, limitation of liability, assignment and subletting, and intellectual property. So if you saw my intellectual property presentation, I talk about all kinds of good intellectual property stuff, and we're going to talk about that in the context of contracts. So term, termination, and renewal. Very, very important to small businesses. Why? Because small businesses constantly change and typically don't have the capital to sustain long-term contracts if the business or market changes. So what should businesses be doing with term and termination and renewal, always negotiate for short term. Month to month is best, or short term, termination notices, so 30 or 60 days. Always ensure that you have proper termination notice in there, so that, let's say you're a tenant, right, that you get, proper termination, and we're going to talk about default, but proper notice of default, and then proper notice of termination as well in your contracts. So that, if there is a termination, you at least know about it and you can start to pivot. And then renewals, be very careful with auto renewals, right? Especially if you've got long terms in here, right? You've got, let's say, it's a 5-year term. And the next thing you know, you look at the contract and you're like, oh yeah, I'm just going to cancel it at the term end. Well, you find out that actually there's a 90 or 120 day notice period that you had to notify the other party to terminate the contract, or it's going to auto renew for another 5 years. Right? That can be really, really scary and really daunting to lock you into another 5 years that you just overlooked the termination. So be very, very careful, and don't always assume that the contract just ends at the end of the term. You sometimes have to give a lot of notice. So I always recommend, that you want an option, not auto renewal, that you can have the option to renew the contract, but you want to be able to exercise it one way or the other. So there's an example here that shows that, the agreement's for a 1-year term. It's got a 30-day initial trial period, but then after the initial trial period, it's automatically renewable on the anniversary date at the end of the trial period with the same terms and conditions. And unless you give 30 days notice prior to that said anniversary date. So it's going to auto renew for a year unless you give 30 days prior written notice to the end of that year. And this one's got all kinds of, fee increases and, federal minimum, related to the federal minimum wage. So you can get locked into higher contract prices in this one on an auto renewal that you really never agreed to. There's some other termination rights in here, but it's only for non-performance. And sometimes that's hard to prove and often goes to, court to litigate and argue back and forth about what that means and whether there was actual non-performance. Default. So as I alluded to, sometimes it's defined as events of default, such as non-payment is going to be the biggest one, right? But it could be bankruptcy, dissolution, reorganization. There could be a corporate change. If you sell your business, that could put you in default. If you bring on a new business owner, if you're under like a loan agreement, that could bring you in default. Under leases, there's all kinds of things that can put you in default, right? If you're not taking care of the property, not paying the taxes, not paying utilities, damaging it, all kinds of stuff, right? So be very careful and understand what types of things are defaults, because you can get into a sticky situation that if you, trigger default and, you might be in breach in a lease, they can come after you for the whole term of the lease. And sometimes they can do that with contracts too, is that if it's a 5-year term and you default after the first year, they have, usually have duties to mitigate those damages, but they can come after you for the rest of that term. So what's important is that you make sure that they have to give you notice of default and an opportunity to cure that default. So to make it right. So let's say they come in and they say, you haven't paid us and you're late on your payment. You want notice of that from them. And then you also want to make sure that you've got a cure period, right? So you've got 10 days after they give you notice to make it right, to pay them. And it works the same way with a whole bunch of defaults. Some defaults you have to be careful. They're uncurable, right? So, and they won't put any kind of cure language in there. But just try and get cure periods and notice. So after there's a default, usually there's remedies for that default, for the non-defaulting party. So if you're in default or have breached an agreement, there could be common law remedies or remedies by agreement. remedies that are listed in the contract. So in a lease is a good example, right? There's eviction, reentry, monetary damages. They can accelerate the contract. They can terminate the contract. They could have attorney's fees, specific performance, which is what we already talked about, or injunctive relief, which is sort of the opposite of specific performance. It's stopping you from doing something. In Ohio, most cases in a contract dispute, attorney's fees are granted only if the agreement provides for the award. So there are some statutes that provide for attorney's fees, some civil claims, especially in the consumer space, that provide for attorney fees, but otherwise it's got to be what the agreement says. And those can be either by, it can be prevailing party, or it can be by enforcement, or it can only be by one party, right? If they have to try and collect from you, they can get attorney's fees too. So choice of law, venue, always try to get this where your business is located, right? You don't want to have to, in the event that somebody sues you, you don't want to have to go and hire an attorney wherever they're at, or get dragged into court over there, based on what the contract says, right? You want to, plus it makes it more difficult if it's not a state party and you put the contract, governing law and venue in Ohio, it makes it harder for them to sue you, right? They're going to have to hire local counsel, come find you, all that kind of thing. So to the extent you can get it in Ohio, that's where you want to put it, right? So this just says that you've got, we're going to look at the state of Ohio is the governing law, because every state's got different laws. And then that we're going to litigate, if we end up in court, that it has to be in Cuyahoga County or wherever you want to put it, Moraine County, Cleveland, Ohio, for any dispute that comes up under the agreements. So indemnification, probably one of the more complicated legal provisions. It's also, I think, fairly misunderstood. I see it a lot in small business contracts where small businesses, put together their vendor contracts, and they don't really know what it means. And so sometimes it's in contracts that it shouldn't be in, as well as sometimes the way they word it doesn't make sense. Essentially, indemnification is an undertaking by one party to compensate the other party for certain costs and expenses. And usually it's for certain costs and expenses that other party would be otherwise liable for. So the best example I can give is, again, in the landlord-tenant situation. Landlord leases a space to a tenant, and somebody slips and falls in the tenant's space. Well, the landlord owns the property, and so premises liability it's their property. They do have some control over it, but the tenant is really the one who's in there every day controlling the property and the premises. So what indemnification is often in leases is it says, look, tenant, you have control over this. You have to indemnify, hold harmless, and defend me in the event that you get sued for this slip and fall or anything else, any kind of third party claims that arise out of, under this lease, right? So somebody comes in, slips and falls, and they sue the landlord because that's the property owner. The landlord gets to point to the, landlord will still be a party to the litigation, but the landlord gets to point to the tenant and say, nope, not me. You have to pay for whatever these damages end up being. You have to hold me harmless for it. And then you also have to pay for my defense costs. That's what that means when you see indemnify, hold harmless, and defend. And usually there's these big long lists of everything to capture all of the various parties and losses that might come out of it. So that's kind of the one big example, but you can see it in all kinds of situations, independent contractor situations where the independent contractor is acting on their own. The company that hired the independent contractor might want to have the independent contractor indemnify them for their actions and omissions, right? To make sure that, because they're not their employee, right? The whole idea of independent contractor relationship is that they're separate, right? But they might be doing some acts on behalf of that company. And so if that person, that independent contractor, does something that, causes damages, and somebody sues the company because they said, oh, you're acting on behalf of the company is going to say, no, we don't really have control over that person. And they've agreed to indemnify, hold us harmless, and defend us. And so they can seek damages from the independent contractor to cover those kinds of damages. All right. Limitation of liability, same thing. This one's a little bit easier to understand, but oftentimes I kind of see it worded wrong or poorly, or it gives more rights than are actually usually allowed. Some people will say, in no offense, they're like any liability for either party in any circumstance, right? Like that's almost not going to be enforceable. Usually what it does is you can limit certain types of damages. And usually those damages are, I'll show you in a minute, they're usually consequential or indirect damages. But typically they exclude, so like I said, they exclude indirect, including consequential damages. They might cap the amount of damages that is enforceable as long as it's reasonable in the context of the contract, right? So that's going to be different for each contract. And usually it aims to limit the party's cumulative liability and to limit the amount of things that can be covered and you could be liable for. And so liability under the contract remedies provisions, whether or not these remedies are tailored as exclusive remedies, including indemnification and warranties. So parties that bear the most risk in commercial transactions typically insist on a contractual limitation of liability. And because without contractual limitations, the party may subject itself to liability greatly disproportionate to the consideration and other benefits it is receiving under the agreement. So, it's a simple agreement, right? Not a lot of money changing hands. You don't want to get in trouble and end up being liable for a whole bunch of money. So the next slide, we're going to look at an example. So this is a limitation on consequential or indirect damages. So it's specific, incidental, special, exemplary, things like lost profits, right? Those kinds of things to limit that. And usually these have to be in caps because you're waiving a pretty significant amount of rights. So they have to be conspicuous. And then you can see the next part is maximum liability, and they've limited it to the total amounts paid under the contract for the 1 year period preceding the event giving rise to the claim. So really it's just limiting it to a certain dollar amount related to the contract. Assignment, subletting. So this is going to be, assignments for any kind of contract, whether it's a lease or not, but here I'm talking about it in leasing. But assignment of contracts, if you can't get the term changed, it's important to have assignment rights, especially if you're going to sell your business at some point. You want to be able to assign the contracts or terminate the contracts and not get stuck with the contract. Make it somebody else's problem, essentially. Same thing, with leases, right? You want to be able to assign the lease. If your business goes under and you're renting a space, you want to be able to assign it to somebody else who can take it over, so you can get out of it and limit your liability. And the difference between assignments mean that it transfers the entire interest on the contract, or the leasehold for leases, to a third party for the rest of the lease, versus a sublease just transfers less than your leasehold estate to a third party tenant. So only a portion of it. And so that might be because, it's only part of the tenant, or it's for a term that's less than the unexpired lease term, or you're remaining liable. You can actually remain liable under an assignment and sublease, but it's very common to remain liable under a sublease. And so the tenant retains its privity of contract under a sublease and privity of estate with the landlord. The tenant remains responsible for all of the tenant obligations under the lease, even if the subtenant is the party that controls the lease premises and may trigger a default. All right, so intellectual property. So some intellectual property rights, notably copyrights and the right to apply for a patent arising out of the provision of services, belong to an independent contractor unless otherwise agreed in writing by the parties. So if you went to my first presentation about intellectual property rights, I said, be very careful when you hire somebody like an independent contractor to do certain intellectual property things for you, create a brand, logo, slogan, design, whatever. Because those start with the independent contractor, unless they assign them to you. If you have somebody working for you, they create a design and scope of their work, it's going to be the independent contractors, not yours. So it's very important to have assignment of all of those intellectual property rights and the delivers and other work product to the company. And here's a big long example of that. But this is a services one where it's saying all the services, which is a defined term, performed under the agreement, and everything, related methods, ideas, concepts, research, proposals, materials, blah, 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 which is they define as the work product. And, all of the intellectual property rights were related to the work product are considered work for hire, which is a defined term under the Copyright Act. And so all of that work made for hire is yours, right? And that if they don't, if it's not deemed work for hire, well, then they also include a later sentence here that says that to the extent that it's, is not, that you irrevocably, as the independent contractor, assign all right and title to it, and that you'll do it in the future should they need it. Very, very important. All right, so we'll get into the insurance section. So we talked about indemnification. Oftentimes, indemnification is tied to insurance, or there'll be insurance to cover indemnities, as well as just, things like independent contractor agreements where you might want that independent contractor to carry their own insurance, right? So if they do something bad, right, not only do you want it to not be your problem, indemnification, but you also want some insurance to cover it, right? Because, somebody's going to sue you as the company, the small business, and then you're going to go over to the independent contractor and you're going to say, defend me, pay me for this stuff that I'm now liable for. And they want a judgment against me because you did this stuff. And they're saying, well, I don't have any money, so good luck. That's where insurance comes in. And that's why it's important to make them have insurance. And also to have small business insurance yourself, which I'm going to get to in a second. And really, all insurance is a contract that shifts the risk of a specified activities from a commercial entity to an insurance company. And its intent is really to shift the risk of liability to third parties, property damage, theft, lost income due to a business interruption. So there's different layers of coverage, right? So there's primary coverage, which is going to begin as soon as the triggering event occurs. There's excess, which is no broader than the underlying, and is not triggered until the primary is exhausted. So this is going to be, secondary excess coverage. And usually this is for catastrophic losses or to fill vertical coverage gaps. And then umbrella is going to provide dollar limits in excess of the coverage limits in the underlying policy. So it's going to, again, fill vertical coverage gaps and expand the scope of coverage provided by the primary policy. So horizontal coverage gaps for different things, and is not triggered until the primary is exhausted. So the bunch of common types of insurance here. So there's commercial general liability, which is also referred to as third party, cyber insurance, first party commercial property insurance, environmental insurance, employment practices, liability insurance. Some people call it EPLI, directors and officers, liability insurance, often referred to as D&O, workers' compensation insurance, errors and omissions insurance, business vehicle insurance, and terrorism insurance are some of the more common types. And so I've highlighted the three that in yellow that we're going to talk about, but workers' compensation and business vehicle insurance, very, very important. If you have employees, you should have workers' comp, and business vehicle insurance, also very, very important to have, especially if you have employees driving your business vehicles. Right. So commercial general liability, third-party insurance. This is going to primarily protect policyholders from losses associated with third-party liability claims arising out of a company's premises and business operations. So typical policies cover claims for third-party property damage and bodily injury, personal and advertising industry, wrongful evictions, libel, slander, privacy rights, all those kinds of things. Provides defense and indemnity coverage for the insured business. So we talked earlier about indemnity and defense. That's why that's important. Contains a separate section listing exclusions, usually that you should refer to. Really talk to your insurance broker, make sure you understand the extent of your coverage, and determine whether the company should purchase additional coverage. It's also really important whenever you have any kind of loss or lawsuit or whatever to notify your insurance company as soon as you can, because usually there's notice requirements to put them on notice to make sure that you have coverage. Even if you don't end up using the insurance, there's still notice issues that you want to make sure that you're aware of. And CGL does not cover professional errors, so that's errors and omissions. So as a CPA, right, you have professional liability insurance for your errors and omissions. That's not going to be covered under CGL. That's also not going to cover employee injuries, which is going to be workers' comp, and it's not going to cover employee discrimination, wrongful termination claims. That's going to be EPLI, your employment practices liability insurance. And then it's also not going to cover damage to the company's own business property, which is first-party property, which is our next slide. And so first-party commercial property insurance is going to provide policyholders with coverages for losses incurred from physical damage to insured property, such as your buildings, equipment, personal property, and stock. And then it's going to give you coverage related to damaged property, including business interruption if you have it. Usually you might have to have riders for these kinds of things, like business interruption, but you might have extra expenses coverage, civil or military authority coverage, ingress egress coverage, debris removal, loss adjustment, a whole bunch of stuff. And then EPLI, which is what I was talking about earlier, it's going to provide coverage for costs and damages for claims an employer engaged in unlawful conduct against an employee, former employee, or an applicant for employment. So discrimination, harassment, wrongful termination, including constructive discharge, retaliation, defamation, libel and slander, and invasions of privacy. So with all of that, we've got about, looks like maybe a little bit more than 10 minutes. Does anybody have any questions? And I think maybe we have one in here.
There is one question here. I am using virtual classes as a self-funding method. What dangers will I be exposed to? I don't understand what a virtual class is, do you? For self-funding?
I have no idea what the question is referring to.
Okay, so
Virtual classes is a self-funding method. Interesting. Yeah,
and the same client saying, how do I insure one piece of paper which is worth $1 billion?
Well, if it's, that's going to be a super specific type of insurance, and probably is very much outside of the scope of this, especially if you're talking about like a security, that's going to be, outside the scope of this. If you're talking about, that's the only real context I could think of is like a promissory note or something like that, that actually a piece of paper, the evidence of it actually has real value. I don't know. That's a good question. I'm sure there's probably, I would say you can insure most things that have dollar amounts on them. So you can probably get, fire insurance on it. There's probably also a specific type of insurance that I'm probably not familiar with, but I'm sure it exists.
It might be similar to insuring maybe a piece of art or something, if it's something of value.
Right.
So another question, when negotiating contracts, which can be several pages long. Is it best to request, or can one request time to review the contract before proceeding to negotiate the terms?
Yeah, I think so. I think that says you're a savvy business person. I don't understand when businesses get offended when you say, "Hey, I want to take some time. I'm probably going to have some changes," right? It's important to understand your bargaining power too, right? Are you dealing with Microsoft, as an individual consumer and trying to negotiate with them, or are you, dealing with, maybe an independent contractor that or a company that has a few employees and you're negotiating the terms, or negotiating a lease with a landlord that's not a very large landlord, but even any landlord, I think leases are something that everybody should negotiate. And it never hurts to ask, right? I don't know of many business situations where somebody says, I want to, gives a red line, and the person says, see you later, beat it. They might say, no, I'm not accepting your changes. But I think it doesn't hurt to ask for things that are important to you. Most of my job is negotiating contracts, right? So I'm constantly going back and forth with drafts of contracts and trying to get them to a point where the parties can agree. So it's very, very common to, depending on what the contract is, depending on what its value is, the longer the longer the agreement, the more value that's into the agreement, the term of the agreement, the longer it is, like that's usually going to make the negotiations longer because we're dealing with a lot more money at stake, right? So yeah, no, I think it's totally okay to ask. I don't know when it's best to ask. I think at the outset is probably best, right? As soon as you get the agreement, say, hey, I'm going to take a look at this. I want to, really read it, understand it. It's important to ask questions too. Don't always take the other side's word for it, right? Especially if it's a complex legal question. But I think it's important to ask questions, make sure that the parties have an understanding of what this piece of paper means, right? And then, maybe make some negotiations, right? Based on your bargaining power.
Whatever you do, don't sign a contract if you haven't gone through it and maybe have your attorney look at it, because we have clients that come in, they signed a contract, they didn't say, I didn't understand what was in the contract. Now they're telling me I have to pay for this. Or we had a client actually signed an agreement and ended up having to pay for an HVAC system for an entire building where they only occupied part of it.
Yeah.
So I can't really emphasize enough how important it is to have an attorney look at your contracts.
Yeah, absolutely. What you just mentioned, the HVAC maintenance, repair, replacement is one of the highly negotiated and litigated areas of any lease, constantly shifting those costs.
What type of contracts do small businesses, say bar or restaurant, encounter or should create beyond insurance or leases?
I think you're probably going to run into maybe some vendor contracts, right? So supply agreements, your supplier, if sometimes they have agreements. I would avoid like exclusivity clauses and that stuff. I think, bar or restaurant, really your most important one is going to be your lease. And then obviously insurance tied to that. You're not going to have any kind of employment contracts. They just don't make any sense in those situations. So I think you probably hit it on the head there, as those are the two most important.
What does terrorism insurance typically cover?
Exactly what you think about it. Yeah. So any kind of terrorist event, right? So if there's any kind of terrorism event that, stops your business or destroys part of your business, right? gives you some sort of lost profits, right? That's what it's going to cover.
Okay. Those are all from Jonathan Bird, who says, that's it from me. Here's another question. When trying to get a contract with huge companies, what area of law in contract should be researched?
Well, I suppose it depends on what kind of companies and what kind of contract you're trying to get, right? If you're trying to get, I guess like some sort of like product sales agreement with a big company, right? You're going to want to understand, right? I guess if you're a distributor, manufacturer, right? Like those are pretty hefty agreements usually. So probably an area where you want to consult a lawyer. But if you're just trying to get an agreement with those people, that's probably outside of my scope. And probably closer to like a business mentor of, how do I get a contract with somebody? But yeah, it really depends on what the contract is for. That's why I talked about a lot of like non-specific agreement provisions tonight versus, diving into very specific product contracts, right? So, a distribution agreement for equipment in Thailand, right? Which is something I'm working on right now. That's very specific. There's very specific issues, depending on whether you represent the retailer or the distributor or the manufacturer, as well as, there's different countries you have to deal with. So dispute resolution is really important. Exclusivity is really important in those kinds of contracts, licensing, all of that kind of thing. And so at that point, you should probably be talking to an attorney about it.
Okay. Are there different considerations with creating business contracts with international companies?
Yeah, I think so. Kind of what I was just mentioning there. Number one of the things we talked about is, choice of law, choice of venue, going to be really important, right? You don't want to have it under, Thailand's laws, which might be very, very different than what you might think is the law in the US, right? And then same thing, disputes, right? How are disputes going to be handled? If you guys get into litigation, are they going to sue you in Thailand or here? Or, and then I think the other thing is, where you might be able to trust and, in the United States, in Ohio, right, dealing with a small company, two small companies operating both in Cleveland, and you got, an agreement between you. Okay, that's fine, right? You know where they are, you know where their assets are. If things go really bad, right, you might give them some credit, right? So you're selling them stuff and, maybe the payment's due in 30 days. I would be much more careful with that kind of thing, as well as, the laws are just very, very different how they operate. You got to deal with export, import laws. International trade compliance is a whole huge practice area of law. So I think those are kind of the big ones, though.
Here's just a clarification about what a virtual class is, saying this is the virtual class. So apparently the person is using virtual classes for fundraising. Okay, I get that, but I don't know what kind of contracts you'd want from that perspective.
Yeah, I don't know that there would really be any contracts that you would really want for that. If you're just doing it, you might want some insurance coverage if you're giving, professional advice. That can be an issue. That if somebody relies on it and tries to sue you for it. But no, I don't know that there's a lot of that you need, contracts, unless you're, if you're accepting payment beforehand, maybe you want a small agreement that says that, this is what you're getting, right? And that there's no refunds and that kind of thing. I think that's probably the most important, is that they're getting that service and that video and there's no refunds, right? Whether they like what they heard or not. That might be something. But otherwise, I think it's probably limited in the value that you get for it.
Oh, here's a good question. What kind of contract do I need for an individual that I want to bring into my small business? If she's only going to use a small amount of office space to see clients a few days a week and provide me a portion of her fee in return.
Yeah, so this is a great question. So this is what is called a license agreement. It's very different from a lease. It conveys less of a property right to them. And it's not a license agreement as in like product branding licensing, it's space licensing. And so there are things out there called a license agreement. So you see it a lot of like in like a beauty parlor, right? They might have a bunch of little where you get your hair done, the chairs. And so somebody might own that, and then they might license out one of those to an independent beautician to use that space. And so that's what a license agreement does, right? It's not a lease, right? There's a lot less limited rights to it. It's kind of shared space, but they get that, non-exclusive right to use that space for a fee. So that's probably how I would structure that as a license agreement if you can get your hands on a form license agreement or talk to an attorney about it.
I think we have covered all the questions.
Good.
So, okay, well, again, thank you, Tyler. It's been very enlightening. And also thank you all for coming. Again, you'll receive a copy of the slides and a link to the recording in the next day or so. And so enjoy the rest of your evening.